made an oral application about a witness that we have not heard about yet until this afternoon, I guess. A witness that he says for health reasons, he didn't want to give a lot in the open courts. And a witness statement has not been filed in that regard. So the court is hearing this matter in chambers. They will determine where next we go with this petition. But of course, I guess the moment that a lot of people are waiting for is to find the Electoral Commission chair, the returning officer in the 2020 presidential elections, in the box. Our update is in association proudly with Petrosol. Clean fuel in full quantity is always a delightful experience. DBS Roofing, we truly are your roof experts. Kwamexha, the immune booster for your general well-being. My name is Mama Vio Swabwaje here with Kojo Yang Singh, and we want to remind you to get interactive. We appreciate that you're following us on social media. Conversations around the election petition, kindly use the hashtag election petition. All right, Kojo. You know, we've had one decision today. We didn't think that we will have processes that we've seen in terms of this hearing in chambers, which came to us as a surprise.
Yeah, and that's the other thing about the election petitions, and I'm sure it happened a number of times in the earlier one. I wasn't here for that, but I certainly am not surprised that we are seeing even what you might have called laid down procedure challenged and tested by the exigencies of the case that the applicant is making. I'm sure when it comes to the respondents, there will also be instances where they will, well, we've already seen one example when Akutampa wished to use a document to refute Mr. Asiedun Ketia's testimony, but the document happened to be one that was attached to a witness statement that was yet to be submitted to the court. You know, so we're going to be seeing lots of examples of what you might consider to be laid down procedure tested, questioned, you know, adjusted, molded in order for the exigencies of this particular case, you know, to be respected. It's going to be a fascinating journey, no doubt.
So the last time the court refused a similar application, which was in the only petition, you know, the election petition 2012, one of the judges regretted not granting because I think he realized that there were some inconsistencies with the pink sheets. And if they had allowed for the document to come from the Electoral Commission, that would have helped. I don't know if we will have similar commentary after this decision. Of course, this decision on this matter has been made. We'll begin to appreciate where the individual judges came from in arriving at this decision when they deliver their judgment. Yeah. Then we'll get a lot of appreciation. In these processes, the reasoning, you'd get very short reasoning, but we will get a lengthier one, proper appreciation of the matters.
Again, I would love to get that education from legal minds on whether, you know, how the Supreme Court's ruling affects the applicant's ability to simply walk to the EC and ask for those documents as a citizen of Ghana, or to go to their website or wherever else it is that these documents are supposed to be. I wonder whether this ruling affects that in any way. I would love to be educated on that, because you know, there must be a reason why the applicant is applying through the court for the EC to submit those documents to the court. Why is the applicant, if they are public documents, why is the applicant not going to bring them and submit them to the court themselves? Why do they want the EC to submit them? You know, these are matters of interest to me. And now that the court has said, no, we're not going to allow you to ask the EC for these documents, if the applicant then goes and gets the documents from the public domain and uses them in court, will they be acting in contempt, or will they be contravening the ruling of the court on this particular application? I don't know. I want to learn. I'm sure many of those who are watching would like to learn as well, as one of the things that we're hoping we can clarify.
Okay, so let's get Justice Abdullahi back if we can. But just want to remind you, the first issue that the court dealt with because they've closed that chapter now, it was an application to allow for inspection of documents. That's an application that Mr. Mohammed's legal team made, but they said it had not been, they didn't get any response from the Electoral Commission. An application that was heavily opposed by the two respondents, in this case the Electoral Commission and Mr. Kufuor's lawyers. The courts went on recess, came back with a decision, and that's a dismissal of the application. So they are not allowing Mr. Mohammed's lawyers to inspect, cross-check, or get any documents from the Electoral Commission. They say no proper case was made by the petitioner. There was also the other matter of they already have the figures, so they didn't have to go over allowing them to get any document from the Electoral Commission. And this is, of course, a matter of discretion, and the courts decides, and that's why they've decided on this matter. It's not necessary for them to allow them to get those documents from the Electoral Commission. But Mr. Chachichikata had raised issues with regards to the total valid vote casts, and he claims in that application that there were different figures, and they're unsure which of the figures to rely on, and that's why they wanted what the Electoral Commission itself had. Now, what we're looking forward to, Kojo, is how this plays out in the testimonies and in the cross-examination that will be given by Jean Mensah.
Absolutely. That is, hopefully, if we're able to get round to it today, that will be the highlight, I think. So far, it has been an exciting morning, no doubt. I never thought that application for documents could be such a dramatic endeavor, but certainly in the Supreme Court, anything can happen, and we've seen how it turned into quite a duel of wits for these documents. Unfortunately, for the applicant, the relief was not granted, or the application was not granted. Yes, it does mean that the testimony of Jean Mensah and the cross-examination of Jean Mensah has taken perhaps some extra significance now, because if the applicant sought certain information from these documents, which are the first respondent's documents, and they cannot get them through the court, when the first respondent's witness mounts the witness stand, that might be another opportunity for them to get those figures. That might be another opportunity for them to get that clarification they seek. And it will be interesting to see how they use that opportunity to that end, and whether or not, in fact, they can use that opportunity to that end. Whether there is there will be more calculators being whipped out or not. I certainly can't wait.
Well, at the end, I guess in the end, we will know, maybe this whole process will put an end to the different figures that we keep hearing from the different sides. That's also one of the things that it would bring closure to the many things that we've been hearing since the declaration of the 2020 presidential results. Our election petition update is brought to you in association with Petrol Clean Fuel in full quantity. Is always a delightful experience. DBS Roofing, we truly are your roof masters. Core Mixture, the immune booster for your general well-being. Well, typically, Kojo, when court is in session, it would not be on television. So that's what is playing out now. Even though the court is in session, it's not. We can't watch it.
Absolutely.
But this is special circumstance because the entire procedure is out there for us to follow, except for this little bit of it where, for health reasons, as pleaded by Chachichikata, the courts must listen to a certain aspect of the case in chambers. So they are considering, at least what we know so far is what was said in the open court, which is the fact that a witness, possible witness in this case, for health reasons, is either unable to be there, or they're making the claim that they want to speak to the court about this witness. So we're not sure if it's the witness that they in turn making the application as in terms of calling to be a witness. But what we know is that no witness statement has been filed. That is to say, in the case of Esiedun Ketia and Dr. Michael Kwesa-White, there were witness statements filed ahead of the testimonies that they came to give. And the testimonies was, what we heard were heavily based on the witness statement that they had filed. But in this case of this witness, we haven't seen any witness statement.
Are we allowed to speculate? Are we allowed to guess?
No, we're not.
Try and figure out who this witness might be. I mean, would we be in trouble if we guessed and we were right or we were wrong? I wonder.
Well, for health reasons, I guess the same reasons that Chachi Chikata gives. Maybe we cannot, because they didn't even put out a name in the open courts.
That is true.
Yeah,
that is true. I mean, we do know that, and I'm not guessing here, I promise you. We do know that there were two representatives of the NDC at the EC that night when the results were being collated. We know there were two. We know that there was Dr. Kwesa-White and there was Rujo Metununu. We know that Dr. Kwesa-White has been called as a witness.
Absolutely.
We also know that Mr. Esiedun Ketia, in his capacity as General Secretary of the party, also had a witness statement, was also called as a witness, representing the applicant. The applicant himself, John Mahama, has not spoken, has not mounted the witness stand. Again, I'm not guessing anything. I'm just pointing out who has and who hasn't mounted the stand yet.
Well, you raised some questions. Let's get Justice Abdullah. Justice Abdullah, I'm super grateful that you could join us again. So he's more like our lawyer on standby. We will come to you often. Thank you for opening your doors. So can I ask what figures would be relied on in cross-examining the EC's witness?
Let me put it this way. If you attempt understanding the petition from the minds of the NDC, they are now appearing to be saying that it is not the figures that they are contesting. I mean, they are not contesting the figures. They are contesting the declaration. Sometimes it's hard to distinguish between the two because one gives birth to the other. But if you understand it from that angle, it means that their cross-examination is not entirely going to be on the issue of the figures, but it's on the issue of the legality or the validity of the declaration. And which would mean that if you gauge their 12 commandments that is sought to have answers to from the Supreme Court when they filed the application for interrogatories and other things, then you can easily guess where they'll be going to with respect to the cross-examination of the Electoral Commissioner. They are likely to naturally enter into the arena of purely administrative decisions, but that is not the core of their, or the crux of their case. The crux of their case, according to they themselves, clearly would be the basis for either the declaration itself and the subsequent amendments, if alleged amendments that were made by the Electoral Commission. If you take it from that angle, then Mamavi, I would say that figures may not be the central focus of the amendment.
Okay. So would the court allow, or should we expect, if you like?
Mamavi, let me just add that. Sorry, let me just add that. After all that I've said, if you take the evidence of Esiedun Ketia and even Dr. Kwesa-White, if you notice, they all refrained from mentioning any figures. So clearly, and that appears to support the explanations that the NDC legal team have been given, that indeed it is not the figures that they are contesting. And I just want this clarification just to re-emphasize the basis of their claim.
Okay, but so far, with the dismissal of this latest application, do you get the sense that the panel is appreciating that fact?
No, that also appears to be in line with that line of thinking. I would not say that they are appreciating or they are even confirming, because really that is something that we all know will come 21 days, from Friday, if you're able to finish on Friday. Of course, which we are not likely to do so, but assuming you're able to finish on Friday, 21 days afterwards, we will know the Supreme Court's decision on all these matters. However, this morning earlier, I remember we had a discussion, and we had all made this point that in the 2013 presidential petition, similar application, but almost the same application, was mounted by the second respondent of today, who was then the petitioner. And the ruling of the court is almost the exact ruling that they have repeated today. It's almost exact. That to the extent that the party already has the duplicate of an original document, there's no legal basis to bring the original because it doesn't serve any useful purpose. Now, this then, drawing this into the conversation about figures, you get the sense that if it is just about figures, then really, the figures are already provided on the duplicate. So clearly, the figures are not the central feature of this whole petition. This is another angle that you can clearly see that the NDC is rather looking at a different angle from this petition rather than the angle of the figures. Okay. Now, if this is the same understanding that the Supreme Court is having, then I think we are likely to have a solid judgment being delivered, satisfactory to all sides, whichever way it goes. Okay. And that will be John Mahama, but not the party, the NDC in this matter. But I wanted to ask you, does it matter that Mr. Chikata keeps insisting that what they have in their possession, the figures don't correspond necessarily with what the EC communicates? Now, the moment that comes in, then the issue of figures then becomes a central point in the suit. Yet, their conduct and their comments outside of the courtroom, and sometimes even in the courtroom, appears to suggest that they are not interested in the figures. So you cannot, in one breath, say that you are fighting the figures, and at another breath, be insisting that the figures are not the reasons why you are in court, but you are in court principally on the basis that the validity of the declaration is the one in issue. So, of course, unless maybe that is a secondary, basis for the whole petition that is presently before the court. Now, if that is the case, then as I've already pointed out, then they will need more figures. They will need alternative figures. They will need a corrected figure from their angle. I mean, other than the figures announced by the Electoral Commission. But I do understand that if you say that the figure that you have on the duplicate is different from the one that was announced, then obviously there will be a need for the original to be seen. There will be a need for comparative analysis to be made. But unfortunately, the law is as it is, that an original is the same as the photocopy. And so whatever the original can do, it suffices to say that the photocopy should also be able to do the same. I do not think that that argument can really be stretched to the limit and for it to be sustainable. Just before Kojo comes in, I just wanted to ask, can there be reconciliation of the figures when the EC's witness is in the box? If it becomes that important, the Supreme Court may be able to make similar orders as it did in 2013. If you remember, in 2013, there was an order on an accounting institution to audit the entire results and came out with figures. With this particular one, I do not foresee that happening. But if it becomes that central, I do not see the difficulties in the Supreme Court making that order. Now, another reason why I think this may not necessarily happen is because after all said and done, there is no solid figures challenging the figures announced by the Electoral Commission. In fact, if anything, then John Mahama is literally saying that we should allow the entire announcement for a runoff to be done. This is the relief the petitioner is seeking in court. Now, if you rely on that relief, then there will be no need conducting any auditing of the figures to come out with any other figure. Because at the end of the day, if you're able to make your case, it is a runoff or a rerun, whichever is convenient or is appropriate or is upheld. That is what will be conducted.
Kojo?
Yes, Justice, thank you for your time. I wanted to check something with you. If I've been following, if I understand the Supreme Court's ruling on this application, they are simply saying that the applicant asked them to exercise a discretion. They looked at whether or not that application meets their, the threshold of necessity. They feel it does not, because these documents that are being requested were provided to the applicants at various levels of the
And I have to rudely interrupt because the court is back in session. We'll continue with this.
Very well.
By court, the petition is hereby adjourned to Friday, 10 o'clock a.m. Friday, the 5th of February, is 10 o'clock a.m. Thank you very much. Be seated. All rise.
Under a is working. A decision has been made. They have adjourned today's sitting to Friday, 10 a.m. What has happened in chambers, we do not know. But what we do know is that the two of the parties in this matter will address us. So we will bring you those interviews when they happen. And we'll also have a conversation with our court correspondent, Joseph Akable. Justice Abdullahi is still with us via Zoom. And Justice, what was I going to say? The moment will come. Okay, we just lost him, but he'll come back and address the issue that Kojo had raised. But let me just remind our viewers, those who are following, perhaps you didn't get that because this happened so quickly. The courts resumed its sitting in the open courts after hearing a certain matter in chambers, and the matter had to do with a possible witness from the petitioner's side. And for health reasons, they did not discuss that in the main courtroom. They came back, and in under a minute, they adjourned sitting to Friday at 10 a.m. Remember, there are 6 days dedicated according to the timetable for the trial. This is day 4. Justice Abdullahi, the reason I'm going to be sending him the memo, because he had said that we will go beyond the set time. And indeed, if we have, at least what we have on the table are 2 other witnesses, Peter McMenu and Jean Mensah. And if the sitting has been adjourned to Friday, consider the time that Akoto Ampao took in cross-examining Esiedun Ketia. And this is Jean Mensah we're talking about.
Well, but you can also consider the time that Akoto Ampao took in cross-examining Pesa White. That might be how
That's
it goes.
fair.
You never know, right? Yeah, that was a shockingly brief cross-examination.
Absolutely.
But I suppose the points that he wished to make were made in the answer to his 2 or 3 questions that he posed. So, yeah, yesterday was fascinating.
Yeah. So how do we interpret what has happened in Chambers? We'll get Justice Abdullahi to help us. Ms. Abdullahi, thank you very much for still staying with us. And I said I was going to wire you that Momo. Yeah. But the fact that they came back and they quickly adjourned sitting, does that give us any idea what may have happened in Chambers in terms of whether or not Chacha Chikata managed to convince them about this witness that we don't know about?
I would say that he managed to succeed in doing something. And that is the only reason why sitting was adjourned. If he had not succeeded, hearing would have continued, because we are barely it's barely 1:30. They could have sworn in the next witness and possibly do some 1 hour, 2 hour business. Of course, it is also possible that they are fatigued, and so they probably would want to have a rest and then continue. But that notwithstanding, there is still tomorrow, Thursday, available for business to be done. But they decided to adjourn to Friday. Now, clearly, that tells you that Chachi was able to do something, because the Supreme Court sits on Thursdays. So the fact that they are not sitting tomorrow tells a lot. I mean, it raises a lot of questions, because it's unusual for that to happen. It raises a lot of questions, and which questions I would affirm that clearly means that Chachi was able to do something good. But as to whether he had what he wanted, I doubt it, because the court would have announced the reason. I'm sure the parties are going to have a backdoor discussion, maybe going forward, before they appear on Friday. The idea is, I'm very, very sure, is to probably be able to have some consensus, so that on Friday, maybe they will probably be able to announce that, or a firm decision would have been taken by Friday, in order for the matter to progress, either to allow the next witness to be called or to continue with the Electoral Commission as a witness in the box. I think, so I believe that's what's happening at the moment.
Mm-hmm. Okay.
I told you, remember, that we are likely not to hear anything at all about what would be discussed, and indeed even the results. And we are likely to just get them calling in the witness or having the matter adjourned. And that's exactly what happened. Once the matter is in Chambers, there's no way anything that occurred in Chambers would be made available to the general public. So this is normal, except for the fact that they didn't tell us anything about what happens tomorrow or the next day.
Yeah. Friday in this case.
Yeah.
So, yeah, Justice, let me get back to that question I was asking. So my understanding of the ruling of the court is that the application of the petitioner to get these documents from the first respondent has been denied because, well, it's a discretion that they are being asked to exercise. They've checked to see whether that request meets the threshold of necessity. They don't think it does, because the documents being requested are documents that were made available at all stages of the election. So from polling station to collation centers, regional and so forth, all the way to the top. So they don't feel that there is a need for them to now use the discretion of the court to compel the respondent to provide those documents.
Absolutely.
But these are documents in the public domain. Would it not have simply been easier for the applicant to, send an NDC rep to the EC office to get photocopies of the documents they need, so they can present them themselves in court to make their point?
So you see why the court will not exercise its discretion in futility. Because if indeed these documents are available, the court will normally not enter into such ironies. Yes, the court has a discretion to do anything if it wishes to do, but it must be the case that if I'm being called upon to exercise my discretion, it is necessary for me to indeed exercise that discretion, not simply because you are asking for it, and not simply because you are even meeting the legal threshold that has been set for that particular application that is being made on me. You may succeed in urging me, convincing me to exercise my discretion, but at the end of the day, if it is an exercise in futility, the court would never entertain such applications. And indeed, and like you rightly pointed out, if they get these documents from the back door and they tender it in, it then becomes the responsibility of the EC to deny the validity of that particular document if they think it is not the original. They would have to then tell the court. So then you'd have them push them to the wall to produce what they believe it is the original or what they believe is the genuine document.
Okay, Justice Abdullahi, I'm afraid we have to cross over again to the Supreme Court for the press conference.
To produce for inspection certain documents. Now, this was founded on a request we made to the first respondent on 19th January 2020 that the first 2021, that the first respondent should produce for our inspection the constituency and regional collation sheets, the regional and constituency summary sheets, as well as Form 13. We also wanted to find out from them the basis for the different corrections that they had made. So we filed an application, and our counsel made it very clear that the reason for which we are asking for all these sheets is the fact that, yes, we have, for example, the constituency and regional sheets. However, we need to know the basis for the different figures that the EC keeps coming up with. You recollect that there's a figure of the 9th declaration, which was quoted as the valid votes. There's the alleged correction that was made on the 10th. There's also the figure of 13,121 plus, which they quoted in their paragraph 24 of their answer, which was a sort of acknowledgement of what we were saying in our petition. So they've come up with different figures. We don't know the basis for which they have come up with those figures. And therefore, we needed to see the originals of those documents to be able to make our own assessment before we cross-examine the first respondent's witness. Unfortunately, the Supreme Court did not agree with our request. It refused our application on the grounds that these are documents that are in our custody. But while the Supreme Court has ruled, there's not much we can do, but we disagree with the fact that all these documents are said to be in our custody, and therefore we are not entitled to it. You heard the two witnesses that have testified so far. Both of them, for example, have said the Form 13. They have never seen or signed the Form 13. And that is at least one document that we don't have in our custody, the most important document of all. We've never seen it. Again, we've made it clear that we were not part of whatever discussions happened at the EC when the different corrections were made. And therefore, we need to see the basis for those corrections. Well, we've been denied that opportunity by the court. But that's not the end. We'll still continue with our case. Questions?
Counsel, at the close of proceedings yesterday, Mr. Chikata had indicated that depending on whether this request was granted or not, it may determine the possibility of calling another witness. We saw at the close of proceedings that another request was made about a potential witness. We know we are not supposed to know the specifics of that particular decision, but we just wanted to find out, is it a case that you are going to call another witness, or has that request been granted and you don't have to file a witness statement for another witness to come?
As you saw, I did not enter the room with the counsel and the judges. We are not privy to that discussion, and it's not for public consumption. That's why it was held in camera. You notice that when His Lordship, the Chief Justice, came and adjourned the case, he did not give any details. I do not have the details either.
All right. We know that he who alleges also bears the burden of proof. You have come to court without certain facts that prior to filing the case in court, there were some communications put out there to suggest that you did have all these facts. Indeed, today we get the impression that this application was an afterthought. You were not prepared for it. You had 21 days to have been able to put all these facts together. Why didn't you do that earlier on? Was it an afterthought?
You're entirely wrong. Maybe you misunderstand our case. We have stated clearly what our case is, and it is based on the declaration of the EC. Based on the declaration of the EC that no candidate got more than 50%. It's based on the fact that there have been so many corrections to that figure, which nobody knows the basis of. And that is why we say that the declaration is null and void. We have come fully prepared for this case. And in any case, the EC is supposed to be an impartial part of this whole election process. What do they have to hide? What prejudice will be occasioned to them if they produce the documents for us to see? None whatsoever. If you conducted your activities as EC chair, fairly, transparently, impartially, why will you not produce the documents for us to see?
I want to also ask about the impact of the application that was denied your side on the case going forward. Are we expecting to see you call another witness, or would say that based on what we have seen so far, the two witnesses you have already called are the witnesses you have to make your case with?
I think you've just asked the same question another guys. You all see what will happen on Friday.
Yeah, I want to find out how strong your case is now, looking at the number of applications dismissed by the court.
We still think we have a very strong case. We are very, very certain about the case we have before the court. Irrespective of the fact that our applications have been refused, we came to court prepared. We are ready to continue with the case, and we will go through with the case till the very end.
The case has been adjourned to Friday. On Friday, are we expected to see your side cross-examining Madam Jean Mensah?
The case has been adjourned to Friday. The Chief Justice did not tell us what is happening on Friday. We'll all see what will happen in court on Friday. Thank you.
So Marietta Brie appear upon the legal spokesperson for the petitioner, one of them. And she essentially disagreeing with the decision, what has been arrived at by the Supreme Court in terms of the request that they put before the court. She says, though, that they have a strong case, and you heard the responses in terms of what's going to happen on Friday. She's not giving anything away at all. I'll come to Kojo. Kojo will tell us about the tempo, because you've been monitoring the previous addresses after each hearing. But Justice Abdullah is still with us. I think he was in the middle of addressing an issue that you raised. Let's get that off the table. Yes, Justice.
Yeah, I'm sorry. Kojo may have to help me, remind me of.
Yeah,
I think I literally finished, actually.
I think you did. I don't know if I can now then ask my little follow-up.
Oh yeah, please do.
I'm interested in your interpretation of lawyer Chachu Chikata's insistence that some of the questions that were asked by the judges yesterday were irrelevant. I mean, if you think about it from a layman's perspective, you are making a case to a court. Now, the judge wants to understand your case, so the judge asks questions. And you tell the judge that the questions the judge asked were irrelevant. I mean, is that not a little bit of a risky strategy, especially since your aim is to convince the judge of your case?
Could you, these are your words. So
it's a question. It's a question.
Well, fortunately for you, you're not wearing a wig. You're not in a room,
so you can. Yeah.
Notwithstanding, when they come after you, don't mention my name. But because could you really, I mean, you got it really right, and I am on all fronts with you on that. I mean, in fact, including your choice of words. Surely, but these kind of comments could only come from Judge Chikata. No one else. Nobody would make such a comment before the Supreme Court. I mean, to be fair, I can't think of any lawyer in Ghana who can use such words before a Supreme Court. I mean, and I say a Supreme Court, not just the Supreme Court, any Supreme Court. I mean,
but hang on, yeah. Justice Abdullahi and Kojayang Singh, what does irrelevance mean? It simply means not related to the subject at hand. What's legally wrong with using the word?
There may not be anything legally wrong, except in our system, we hold our judges in the highest form of esteem that you can possibly think of. And because your hands are literally in their mouths, you would be very careful in the choice of words. Remember, as we always say, the case is not even your case. It's your client's case. If out of the indignity of the judge, he decides to visit his anger on your client, the client is a loser, not you as a lawyer. Even though
isn't it ultimately your case? But I want us to get something clear here, because a lot of lawyers agreed to the fact that some of the comments were not questions, but they were commentary, almost judging, if not judging, the attitude of the witness or the performance of the witness, doing a certain responsibility or a certain job. I guess those are extra comment outside the questions that he asked.
I mean, just before Justice comes in, I guess the question is, what is the value of the strategy of pointing out to the judge that in your view, their questions were irrelevant? As a strategy, how is that helpful, I guess, is my question.
I guess
maybe if I should aid Jansen in this matter. I'm sorry, Mavi. Let's be fair. How does labeling a judge and his comment as irrelevant advance your case before the court? Absolutely none. At the end of the day, we should all remember that the court is the determinant of what is relevant, not the parties. You don't determine what is relevant. You can determine what is relevant to you, but the court determines what is ultimately relevant before it. And so it is the court that determines, in fact, matters of fact and matters of law are the complete, are within the complete jurisdiction of the court to make a determination of, and not the parties who are appearing before the court. And so, indeed, for you as a lawyer or as a party, the question or the comment may not be relevant. But at the end of the day, the court is the one going to write the judgment. And you may be the best lawyer in the world, but if the court thinks otherwise, I do not know how your credentials as the best lawyer in the world can save that situation until you probably go on appeal. In this case, only on a review. And if you're not lucky and it doesn't go well, you would have shot yourself in the foot. And that's highly unwarranted. It's clearly unwarranted. But I do understand that sometimes our emotions take the better part of us. And if you remember, I'm sorry, Mama B, in the morning, I had mentioned that some of the comments made by Justice Apple, for instance, beyond asking questions, were probably not appropriate because they were not matters that he could have decided to avoid it. There were nothing that he could have restrained himself from going into the arena of labeling the witness as having derelict on his duties and all of that, and doing the petitioner a disfavor. I do not see how that is important in the determination of the matters before the court. At the end of the day, the court will rely on all those matters and make their commentary, and that will be more formal, and it will be on record for the rest of our lives. And so that, for me, you can look at it from that angle. But to question the relevance of questions posed by the bench, I don't think that is proper. I would never do that. And of course, I may not be anywhere close to the lawyers for the petitioner, but in my small, humble practice, I think I would restrain myself in making such commentary. I do not see how that advances my case. Really, at the end of the day, what is the benefit? What's the probative value, probative benefit of an attack that I launch on a judge? Nothing. Absolutely nothing.
Is that something?
It's like punching your wife in the face. I don't know how you benefit from punching your wife in the
but
face.
But is that something that the court? Is that something, Justice, that the court will take notice of? Is that something that could hurt a person's case?
Legally, it shouldn't. Legally, it shouldn't, because at the end of the day, the court doesn't operate with emotions. The court is supposed to operate with law and procedure. And so the fact that even a lawyer had misconducted himself and even had used raw, insulting words before a court should not affect the merit of the matters before the court. And if indeed it finds its way into the judgment, I think that would be improper, and that would be unfair to the petitioner and indeed to any other party who is victimized as a result of the misconduct.
Justice, unfortunately, we have to end it here and cross over and join Kojo Ponkroma.
Payments are 47% for the petitioner, 51% plus for the second respondent. We were informed that he intended to put a second witness in the box who adduced further evidence that nobody crossed the 50% mark. Dr. Kwesa White was put in the box yesterday. The crux of his evidence was that he and Mr. Rojo Metonunu were deceived by the EC chair with an instruction to leave the EC premises during the collation. And upon further cross-examination, he admitted that the EC chair could not actually instruct them so to do. We have been waiting for the evidence or further witnesses who will provide evidence that nobody crossed the 50% mark. This is the government of their case. Today, we were seized, or the court was seized with an application that was filed yesterday. And I heard our colleagues who just left say that this has been there for a while. It's not true. Check the date on the application. This application was filed yesterday. This application was filed yesterday. In fact, it was filed. It was served on us yesterday, but it was filed the day before. So this claim that this application had been put in way ahead of time is not true. That's why you heard our counsel talk about 34 days after the initial application. But be that as it may, this application is aimed at giving the petitioner an opportunity to go and inspect some documents. Inspection of documents generally is allowed in litigation, but it is not a matter that you have as of right. It is at the discretion of the court, and you have to convince the court or establish something before the court for the court to grant it. You have to prove that there is some necessity for you to be given leave to inspect those documents, because among other things, it will be necessary for the fair disposal of the matter. Without it, there will not be a fair disposal of the matter. And that it may also be necessary to reduce the cost of litigation. You heard Mr. Chachuchikata on his feet for about an hour, trying to establish the necessity for which they should be granted leave to inspect these documents. And you heard counsels on the side of the first and second respondents argue that no necessity has been demonstrated because all of those documents are already in the custody of the petitioner. and the petitioner has not demonstrated before the court that there is anything wrong with the copies that he has, and therefore asking to inspect the originals, because you have the documents already. Indeed, some of those documents were attached by the petitioner himself to his petition, some of the witnesses as well to their witness statements. And so the principle, the legal principle of necessity for fair disposal of the matter has not been demonstrated. And there has been no argument even made about a reduction in the cost of litigation. We also noticed, principally, that as the case moves on, and particularly with this application, the petitioner is now seeking to invite the court to breach a time-tested rule in litigation that he who alleges must prove. You come to court with your own case and your burden of proof is on you. It is when you have satisfied what we call a case, you have made a case in law, that the burden of proof now shifts onto the respondent or the defendant to respond. Indeed, if by the time you are done, and for those of you who are court correspondents, you know, if by the time you are done submitting what you think is a case, the legal threshold of making a case under the law has not been made, the respondents or the defendants have the opportunity to move a motion for no case because you have not made a case. So it is when you have moved a case and satisfied the legal threshold that the burden of proof shifts. We are observing that this is an attempt to shift the burden through the back door. Now, the court, as you observed, rose to consider the various arguments and came with a ruling. Before then, plaintiff had made an argument that if you have nothing to hide, why don't you produce the documents? Those documents are even on the internet. They have been published already. They are within the custody of the petitioner. So don't be swayed by this propaganda line that if you have nothing to hide, why are you not producing the documents? The documents have been made available. They are already in the custody of the petitioner. They are in the custody of all other political parties or candidates who took part in this election. They are in the custody of the second respondent, and they have not demonstrated any necessity for it. In the end, the court ruled, and I just want to quote what the court said through the respected Chief Justice. Said the applicant has not demonstrated the necessity that must be met, and that indeed on record they have admitted that they have the documents. No proper case has been made for this application, which we have spent a number of hours on today. And if you look at section, I think 166 of the Evidence Act, they have not raised issues of authenticity even, and therefore it is not the 1 hour submissions and English that would invoke the court to exercise its discretion in this matter. You must ground it in law and prove same. We are of the view that the pendulum swings back to the petitioner, who had advertised that he has 5 witnesses who will give evidence to show that nobody got 50%. We've heard the first 2. The jury is out on that one. If there are 3 other witnesses, now will be the good time for them to either submit those witnesses to adduce this evidence that shows they are supporters that they told they had won and then they came to change the story, but that will show them that indeed nobody won. Or if they are not able to put further witnesses before the court, then they would have to bring down their case, and then the respondents will also have to now move to their next line of action. We think it's generally been a good day in court for justice, and we look forward to the directions of the court on Friday.
So, Mr. Minister Designate, Mr. Kojo Nkrumah, 2 questions. The first one is that we've noticed that in court, most of the time the petitioner's side is doing very long arguments, whereas the respondents, both you and the EC side, do very little arguments. What's accounting for this? And again, every time we've come to court when there's an adjournment, the Chief Justice will indicate what will happen next in the next sitting. This adjournment, there is no such indication. Can you give us some indication as to what we should expect at the next sitting?
I mean, obviously, you saw the bench invite lead counsels into chambers and have a set of conversations with them. We were not in chambers, we were not privy to it. It was something that obviously they did not want to advertise in open court. I am sure that that has an influence on the adjournment and the directions for Friday, but we are not in a position to say because we were not in there. We'll look forward to whatever the Honorable Court will put out on Friday. But to your first question, Yes, as a matter of fact, you notice that counsel for the petitioner sometimes has about an hour. In fact, today you noticed from about 9:30 something to about 10:30 thereabout on his feet making arguments. And counsels for first respondent and second respondent are very crisp in their responses. It is because this is a court of law, not a court of public opinion. When you make an application before the court, you must satisfy what the law requires and back it with authorities that are relevant or the legal invocations that are relevant. For example, if you recall the application for leave for supplementary, counsel for the petitioner was on his feet for several minutes. But if you listen to the ruling of the court, it says that even the authority that you cited, Elistamaklu, has nothing to do with supplementary applications of this nature. And the expectation that you will give us good law to back your application did not happen. So we are not invoked. Counsels on our side, you would notice, are limiting themselves to the law and the legal requirements, are not necessarily arguing with the bench, and are speaking to matters of law. So what does the law say? That is what we are interested in arguing. So if under CI 127, under Rule 44, there's a clear provision that forms are set out and must be made available to all parties. All we need to do is to invoke that. We don't need a lot of grammar to make our case. And that's why you would have noticed that we are not spending too much time speaking English, but we're speaking law.
Being a journalist yourself, you understand how we get when we don't get the information we seek. So, follow up to his one of his questions. Do you have and can you help us with any indication as to what would happen?
Okay, that's Kojo Paul-Kroma there answering questions from the media and addressing the media after today's sit-in. Joseph Akableza, court correspondent. Joseph, just before we wrap up, what did you, or have you picked up anything from that hearing in camera?
No, Mama V. So far, we have not been able to get information. We are still digging and checking with our sources. But what we know for a fact is that there was a request that was made that what has transpired suggested has been granted, in the sense that the request was to the effect that there was a witness that due to health reasons they would want some direction. So we are coming back on Friday. We do not know what the specifics are, but we are just looking at the ways to get some Friday.
Joseph, that will be it. Thanks a lot, Joseph Akableza, correspondent. He will continue with the update on Friday, God willing. Kojang Singh, we have to go real quick and make way for sports today.
Absolutely. It's been quite a memorable day in court. We've seen the interpretations of both sides, as usual. One is accusing the other of speaking English while they speak law. And the other has been, philosophical about the denied application. In the end, I think the way we move forward is what matters, and we'll see all of that on Friday. Absolutely. Thanks to our supporters, really. Petrosol, clean fuel in full quantity is always a delightful experience. DBS Roofing, we truly are your roof expert. Kwamexsha, the immune booster for your general well-being. My name is Mama Vio Swabwaje. I've been here with Kojang Singh. Thank you so much for your company. For those watching on television, we'll bring you sports today with Nathaniel Attel. We will see you on Friday with another election petition update.